You may not have the right to sell or refinance your own property, even if you are the only owner listed on the deed. Today you'll learn why that is and how to determine if this restriction applies to you. I will go over some of the pros and cons of the different forms of property ownership recognized in the state of Florida, so you can make sure that the vesting on your deed, which simply means the way your title is held, is the right option for you. The vesting language on your deed not only affects your legal right to sell or refinance your home, but also affects what happens to the property after you pass away. The first option is sole ownership. This is when one individual is listed as the only owner of the property. However, if that individual uses the property as his or her primary residence and is legally married, then their spouse must sign off on the deed to sell or the mortgage to finance that property, even though the spouse is not a named owner on title. This is due to the protections granted to homestead property by Florida's Constitution. An important fact to consider when deciding whether sole ownership is right for you is that upon the death of the sole owner, a court proceeding, either to administer probate or to formally determine the property as having been homestead property that passed to the owner's heirs, will likely be required. A better form of ownership for married couples is as tenants by the entireties. As we get into the options for more than one owner, keep in mind that the general rule is that all owners listed on title have to sign off on the decision to sell or finance the property. Tenants by the entireties is the default form of ownership for a married couple who are listed as married to each other on the face of the deed. This form of ownership offers protection from creditors of each individual and passes the deceased spouse's interest to the surviving spouse automatically as a matter of law without the need for a court proceeding. Similarly, the third form of ownership, joint tenants with rights of survivorship, will pass one person's interest to the joint title holder upon the passing of one owner without the need for court proceedings. This option can be used by multiple owners regardless of their marital status or relationship to one another. But if one of the multiple owners is a married person and it is his or her primary residence, then I recommend consulting with an attorney to be sure that the intended vesting doesn't violate the restrictions of Florida's homestead laws. The fourth main form of ownership is tenants in common. This is the default form of ownership in Florida if there's no language to the contrary on the face of the deed that has more than one owner. It's used for owners who either want their interest in certain percentages or do not want their interest to pass to the other owner upon their death. All owners will have to sign off on a decision to sell or finance the property unless it's the rare occasion that only a percentage of the property is being sold or financed. If someone passes away, then their interest in property under a tenancy in common will require a probate court proceeding to determine the rightful owner of the deceased person's interest. In addition to the four main types of ownership that I just described, you can also opt to vest title to your primary residence in your revocable trust and still qualify for that homestead tax exemption. For investment property, you may want title vested in the name of a limited liability company or a corporation. In these instances, you'll want to keep clear documentation of who has the authority to sign off on decisions to sell or refinance the property on behalf of the entity that holds title. If you want to update how title to your property is held, text 561-225-2676 to set up a time to speak with me.